as void. And in our yesterday session, we have discussed in length what it exactly means. Can you help me to recall? So I'll repeat the question for people who are joining right now. So the question is that in one of the essential element is you're not expressly declared as void. So can anyone help me to understand what exactly mean? I have already told you in yesterday's session. Or shall I call somebody's name here? Sachin, are you there in yesterday class?
No, ma'am, I wasn't there in the yesterday's class.
Okay. Shall I take somebody's name by myself or somebody will come? Ananya, you were there in the class? Saswat, can you help me?
Yes, ma'am. Ma'am, can you please repeat the question once again? I could not hear.
Okay. So one of your essential element is you're not expressly declared as void. So what do you understand from this? We have already understood it in length in yesterday class.
Basically, that's what means there is no restraining on it so far.
Can you repeat it?
Ma'am, not expressly declared as void means there is no provision that is explicitly declaring it to be like voidable. Sorry, void.
So yesterday topic was, we have discussed it.
Ma'am, voidability of contracts. Void, voidable, and illegality of contracts.
So I have specified that illegal contract and the void agreement both are your void from beginning, right?
Yes, ma'am.
So a contract need to be not expressly declared as void. So illegal contract and the void agreement both are declared as void. That is expressly declared as void, correct? Or having confusion?
Ma'am, I understood it.
Rest? Are you able to take it? Or you have differing opinion? See, not expressly declared as void, it means must not be either illegal or void. When we are saying about illegal, then it should not be expressly provided by law, right? When we are saying about void, then it has no legal effect, correct? Yesterday this is the discussion. And void doesn't mean it should be illegal. It may or may not be, correct?
Yes, ma'am.
And the void agreement, the collaterals are not necessarily be illegal. Everyone are on the same page? And we have
Yes,
also
ma'am.
discussed about yes, so we have also discussed about in case in illegal contract how it in what circumstances the contracts are illegal. Like we have discussed about unlawful consideration and unlawful object. I have shown you the De Danadan movies clip as well for that reason.
Yes, ma'am.
Yeah. So we so in case of unlawful consideration and unlawful object, we have discussed prohibited by law, fraudulent, injury to a person or property, immoral, and we are discussing that time opposed to public policy. So I have given you certain task. Anybody has researched over it or still pending to do? In case of stifling prosecution, I have mentioned lot of questions I have given as a task. Anybody has researched? Nobody? If you are not working upon those questions or not participate, then it will discourage me to continue. The whole objective is like everybody should know have clarity about each and every concepts. And in case if you're not able to find out the answer also, or if you have any kind of confusion, then discuss. Okay, so I keep this as a task. In Saturday Sunday you will work upon this. With regard to champerty also, I have given lot of questions. Okay, this is one questions. Right now we can start with this. Don't you think champerty is a legal arrangement where a third party provides a financial support for a lawsuit in exchange for a proportion of the proceeds? If this case is successful, like the other person is helping, right? Because the party involved in the litigation is not having the fund. So how come it is against? I mean, it is against opposed, or it is opposed to public policy? I think you are not revising the concept itself. I'll keep it as a task only. Will not discuss this. So the other example of opposed to public policies are trafficking related to public offices and titles. Okay, so in case suppose if you are no getting a recruitment without having proper eligibility or through a wrongful means, then it is against the public policy. Or if suppose the department is inducing for a voluntary retirement by giving certain amount to you, and you are not intending to retire, but because of that inducement you are retiring, then again it is an example. It is a right case for the trafficking related to public offices. Or if you are no procuring any title, like any title which is given by the government, then in that case also it is trafficking related to public office and titles. Okay, next point is your agreement tending to create monopolies. So, is there who can do the monopoly? The private individual can run in a monopoly. Which kind of economy we have in India?
Madam, mixed economy, mixed
Capitalist.
economy.
Ma'am, it depends
Okay,
on an
and
arrangement.
mhm. So in macroeconomics, also you would have understood this concept. Is a private
Yes,
individual?
ma'am.
Is private individual can run a business in monopoly?
No.
And it will hit certain act, right? So if any kind of agreement, certain act means like competition act, there are other many act which are prohibiting this. Okay, so agreement, any agreement, if you're entering into no, to create a monopoly, then it is against opposed to against your public policy. But if the government is doing such, then it is not, because in mixed economy we have the balance of both. Like railway is with government. The private individual cannot run a railway, correct? Your next point is your marriage brokering agreement. So we have discussed yesterday about this, in which case it is allowed and which in which case it is not allowed.
Ma'am, if the parties are not attaining the age of majority, then the marriage can be restricted, ma'am.
This is about broking agreement. So what exactly is happening? Like suppose if somebody is no, arranging a bride or groom for the other for the purpose of any reward, monetary reward or any kind reward, if certain reward is involved, then it is against a public policy. But if it is no, only providing any kind of information, like many matrimonial app which provide information, so if that is there, then it is not, it is allowed. Okay. And seventh point is your interference with the course of justice. So you have seen in many of the movies or in the practical, if you are practicing also, you have came across that many of the witness are same person is witness in many of the cases. And these are called in, in in real world, these are called certain, the terminology is given. Let me know by researching over it what they are called. Okay. So if it is done like that, then you are interfering in the course of justice, because that person is not the real witness. It is he is just a dummy witness who has been no, narrated the entire instance and given, and to be told that "Okay, okay, you have to just say like this." Okay. Or if you are just or doing any kind of other corruption, then in that case you are interfering with the course of justice, and it is opposed to public policy. Next, your interest against obligation. So if certain duty is already there to perform, for which you are getting salary, and for performing that duty, if you're taking certain money from the any individual, and that's what called corruption, right? People are doing the duty which they have, they are obliged to do, but for that also they are taking certain money from the poor people, right? So if they are doing this, then it is against the your public policy. And ninth point is your consideration unlawful in part. So if suppose if in agreement or in contract, if certain part is your valid and the certain and the rest of the part is not, like if suppose the half of the consideration amount is legal but the half of the consideration amount is illegal, then in that case the rest of the part will be severed. It will not, but it will not consider that if it is no if you could not able to sever it, then in that case the entire contract is void. But if you can, then the rest of the part is still functionable. Any question? expressly declared as void agreement. So we have discussed about wagering agreement yesterday. Anybody who can tell me what exactly wagering agreement are?
Ma'am, it's a contract where it's an agreement where one party agrees to pay money on the happening or non-happening of an event.
Yes, but most important is they are not interested in the underlying part. Otherwise, it will become a contingent contract. So they shouldn't be having any interest apart from that win or loss. So whether it rain or not rain, they are not interested on that. They are interested on the underlying amount. But there are certain wagering agreement which are not void, and those are your, like, if you have seen speculative transaction happening in the stock market, right? So in the speculative market, or if you see of future and option, so in that dealing also, if you have heard that terminology, so there also similar thing is that the people are interested about the money, but again that is not void. And cheat fund is not a wager. Your share market transaction, as I mentioned, game of skill and crossword etc, so these are not your wager. uh, if you want to have a detailed understanding of game of skill and crossword, because if in OJS any previous questions came on this topic, then we will discuss it in length. Okay, let me know what if is there any question, because it is again a one topic. And for horse race, if the price value is not more than 500, then in that case also it is not a wager. And in case of a contract of insurance, this mean lot of prelims questions are coming from contract of insurance as wager or not. So this you have to keep it in mind, that contract of insurance is not an wager. We have discussed about standard form of contract. So can anybody tell me the key pointers which you have to write, because I think that is repetitive questions in OGS. What is the key understanding of the standard form of contract? In second class, I think I have explained.
Ma'am, it's like a take it or leave it agreement.
Correct, Ananya. And in what ground, if suppose if certain clause is there which is not reasonable, then you have already signed it. So if you sign it, then it is a valid contract only, right?
Yes, ma'am.
Yes. And if any clause is not no reasonable, then in that scenario, what about that clause?
Ma'am, you have to totally leave that contract.
No. It is not like that. You the only that clause which is unreasonable will not be functionable, and the rest of the part will be still functionable. Okay, but suppose there is certain thing which has to be mentioned and it is not mentioned, that is again not to be imposed later on. And the notice of standard the clauses should be also given to the people. Okay, I mean to the person who is entering into the contract. And the same has been mentioned in Raipur Transport Company versus Ghanshyam. So if any special condition is there in the standard form of contract, but it is not noted there, then, or if it is not communicated prior to the date of contract, then that is not binding on the owner of good. Okay, so if any questions come with regard to standard form of contract, what is standard form of contract you have to mention. And if any clause which is there which is not reasonable, then what is reasonability test you have to provide. And then you have to mention, if it is not reasonable, then what about that clause, whether it is functionable or not, and what about the rest of the clauses. And you can give certain example like Russian app, which I have given you example, and the your employment agreement. You can also go through this. I'll just no Just a minute. I'll put it in the chat box. So you can go to that link, which has in detail understanding of your employment agreement. This is written by me only, so you can go. You can have a content over that. So we have discussed that topic in length in our second class itself. So next, your rules regarding valid offer. So we have understood that agreement means your offer plus acceptance plus consideration. So one person is giving an offer for what is the expectation? If somebody is just saying that, okay, I'm going, will you go to no go to a park with me, and you simply went, so is that a contract, or is that an offer?
Ma'am, it's offer.
You told something, okay, बट यू वेटेड फॉर, मतलब आपने ऐसा कुछ भी किया जिसमें आपका एक्सपेक्टेशन था कि उससे रिप्लाई आपको चाहिए, आपने बोला और आप चले गए, राइट शाश्वत?
Yes.
You have not mentioned where you are going, where, which park. No, I am waiting outside, nothing has been specified by you. You simply asked, will you go to park with me, and then you went. So the underlying part is that you should have an intent to get the acceptance. Can anybody tell me the definition of offer by seeing the Barrett? I have given you the
Ma'am, it
task in
was
first class.
ma'am, it was provided in section 2A of the Indian Contract.
Mm-hmm. Yeah,
When
what
one
it
person
says?
signifies when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he said to make a proposal.
Yes, but you have just in this example what happened? Have you do you have any no intention to obtain the assent of that other person?
No, ma'am.
No, ma'am.
Right now, so here if you see, when one person signifies to another his willingness to do, so here you're no in like you're going to a park, that is something to do. But what about to abstain from doing? Will you able to no give any example with regard to this terminology? To abstain from doing, कुछ करने के लिए आप ऑफर दे रहे हो, वो समझ में आया। किस लिए दे रहे हो आप ऑफर? क्योंकि आपको उस एसेंट भी चाहिए दूसरे पर्सन का कि उस एक्ट पे, राइट, कि कुछ होना है आगे। बट व्हाट अबाउट टू एब्सटेन फ्रॉम डूइंग एनीथिंग?
Ma'am, you should not do that particular thing.
अच्छा, मतलब मैं पार्क जा रहा हूँ, तुम मत जाना, ऐसा? मतलब कुछ एग्जाम्पल आप बोल पाओगे ऐसा कुछ?
Ma'am, suppose I am selling a property to anyone. So someone I am selling the property, and okay,
हम्म।
uh, suppose I am telling that don't cut the particular trees. Like I'm not able to reframe it.
हाँ हाँ, मतलब आप ये बोलना चाह रहे हैं कि हाँ, मतलब एक पर्टिकुलर ट्री है, उसको आप मत काटो, एंड दिस इज एंड ही इफ द अदर पर्सन एग्री, देन इट इज अगेन ऑफर एक्सेप्टेंस एंड बिकम अ कॉन्ट्रैक्ट,
Yes, madam.
करेक्ट? हाँ, सो देयर एग्जिस्ट वन ट्री, ठीक है? अभी मैं आपको बोल दूं कि आप मान लीजिए आप स्मोक नहीं करते हो, ठीक है? और मैंने आपको बोला कि आप बिल्कुल बिल्कुल भी स्मोक नहीं करते हो, और मैंने आपको पूछा, मैंने आपको ऑफर दिया कि यू विल नॉट स्मोक इन योर लाइफ, ओके? एंड फॉर दैट, इज दैट अ वैलिड ऑफर?
No, madam.
Because in the example which you have given, there is already a tree existing. Are you sure? Is anybody having different opinion over it? जो आप नहीं करते हो, उसी को ही मैं आपको बोल रही हूँ नहीं करने के लिए, और उसके बदले में सपोज आपको एक अमाउंट बता रही हूँ कि हाँ, आई विल गिव यू 1 लाख रुपीज फॉर दैट. सो नाउ इट हैज ऑफर, consideration, and acceptance can be possible. But what my question is, whether this offer, whether it is an offer or not.
Yes, madam, it is offer.
Okay, and why you say so?
Then there must be a possibility that in future, in near future, he will be smoke.
Okay, correct. So he is giving up his future right.
Yes, madam.
Okay, now he might not be smoking, in past he has not did that, but in future he might do, but he is no giving up his future right.
Yes,
So abstain from doing. So this is again offer. I hope it is clear. Now rules regarding valid offer. So the offer might be expressed or implied. We have already understood this. Just a minute. I think
Having never done something.
just. So I don't think it is required to be explained again. But with regard to a specific or general, so if I say that specific offer, it is to be given to a person, or it can be given to a group of person. Or if it is given to a group of person, then it will be called as specific, or it is called as general.
general offer, madam.
Okay, Soumya is saying general offer. Anybody else?
Specific.
Specific. Why, Anusya?
Because it denotes to a specific group of people.
Correct, very much correct. Because that group has only right to accept that offer, and not any other person in the public. Okay, Soumya. So
Yes,
it is
madam.
a specific offer. It is if it is given to a specific individual, or if it is given to a specific group of people, then also it is a specific offer. And in case of general offer, it is given to a public at large. And there is certain no conditions where, like what exactly need to be no compliant. And one case is the case law is there. I think everybody would be knowing that.
Carlil versus Carbon. Smoker.
Yes. So if you comply all these no criteria which has been provided, then you need not required to communicate the same. If you have no complied those terms, then it is an acceptance. But in case of specific, you have to expressly or impliedly have to you have to communicate that part. Third is your intent to create legal relationship. we have discussed about the intention. What exactly it means? In key, if somebody will able to give in a key point, the crux of the understanding.
Same thing in sentence.
No, no, no. That is your consent. So, may you were there in the first class?
No, madam. It is in first class.
Okay, okay. So, intention has been explained in first class, that intention should be your objective intention and not the subjective intention. Okay, and the intention, the objective intention is to create a legal relationship. And that what it implies, that the other person will have a legal obligation to know whatever the promise that person is making has to fulfill that. That's the key understanding, and for that we have given lot of example and lot of no case laws we have already discussed. And fourth point is your offer must be communicated to the offeree. So it should be communicated to the person who has to accept it. If suppose if you give an offer, if you intend to give an offer to a flat number 1, and that person is not there, and you just no communicated to the flat number 02 to inform that person of 01 person, right? So do you think it is a offer, a valid offer?
No, madam.
Yes, because it has to be communicated to the offeree from whom you are expecting the acceptance, not to anybody else. And for this, there is a very landmark case. One is your Lalman Sukla versus, I hope everybody know. Okay. And the fifth point is your, it should be certain, definite, and not vague. So I have given you example about certainty. Like one example, we have discussed about the oil. Okay, wherein the if somebody is giving an offer to buy an oil, but he has not specified which oil, right? So it is not a valid offer. Again, it should be for a definite time period, not for a perpetuity. And we have discussed one example wherein in case of an education, the that lady is no continuing it for more than 10 years, but it should be expected to complete by 3 years, right? So if you are saying certain things like to do certain, but you have not mentioned the time length, then again is it not a valid offer? I just, if you twist that same example, and you will think that okay sir, the timeline should be also provided. You will not think that okay it has to be continuing forever. Okay, it may be conditional. So what it means, an acceptance can be conditional, or it is only with regard to offer, and what it means by conditional.
Ma'am, acceptance must be absolute as per Indian contract.
Yes. So if I say that like you are allowed to I'm off if you are saying that I want to sell my if you're saying, if you're giving an offer to somebody with regard to your selling your property, but you are also giving a condition that the same it should not be the further no floor should not be added with regard with that property. So it is it possible?
Ma'am, if it absolutely restrain the owner of the property, then it is not. As per the Transfer of Property Act, it is not possible, ma'am.
No, so you have to read the section 10 and 11 that part, because one is about your certain conditions and the condition precedent, considered subsequent. Okay, and one is about absolute restraint of further sell. So all those things have to be seen when we are giving a maybe conditional. We also need to read those sections as well, because if in exam suppose certain kind of property law questions came with regard to this offer also, you if you link both the sections, both the act, then it will be nice. But suppose if you are saying giving an offer with regard to, for a conditional offer, I will go with you with you for a trip only when if you wear red cloth, otherwise not, then this kind of condition is also valid. Okay. But in case of acceptance, the other person might accept it, might wear red dress, or might not wear red dress. If he is not wearing the red dress, then the acceptance is not absolute, and there is no contract. Okay. And the seventh point is maybe positive or negative. Anyone able to make me understand what is positive or negative offer?
To do a act that is
Ma'am,
positive
I think
and
it
to
means
abstain from doing a act.
Mm-hmm.
yes, ma'am. To do a act, it is a positive offer, and to abstain from doing anything is negative.
Correct, correct, very much correct. Okay. Made with a view to obtain assent of other. We have already discussed it. Now, not contain a terms non-compliance of which amount to acceptance. So, I have discussed with you with regard to silence versus conduct. So, now please connect here. Because every class is very much important. If you know miss one class, you will, everything is connected one after another, right? The first few classes will be a foundation for all the understanding which we are going to do it in later classes. So not container terms, non-compliance of which amounts to acceptance. So suppose if you give an offer that if you're not replying within 3 days, then I will consider it as accepted. Do you think it is a valid offer?
No, ma'am.
Or if you will remain silent, then I will consider it yes. Like I offer you to marry, but if you will not reply, if you remain silent, then I will consider it that you intend to, you are accepting the marriage proposal.
No, ma'am. That kind of consent is not valid.
Yes. So that type of consent, or even if in anything, if you're saying you're putting it in offer itself, that if the person liberty to say that is forfeited, then then itself the offer is not valid. Because it should be, again, the acceptance may be expressed or implied, but you cannot say that silence, if the silence will amount to acceptance. And in case of implied, the conduct will be different. With the silence and with the conduct, we should not be consider that the silence will amount as conduct. There is a difference between silence and conduct. You can also understand in the second class in detail. We have discussed that part. Again, 10th point is answer to question is not offer. So there is one case, Harvey versus, I hope everybody know that. So in that case, it will be discussed that the offer was there. There is an offer that do you have certain pen, and he said that yes, I do have, and he asked the price of that pen, and the other person has given the answer that only about with regard to the amount of what is the amount he has to pay for buying that pen, but he has not mentioned that he is intent to sell it, or yes, he's intent to sell that. Okay. In that case also, it is not a valid offer, because reply to a question with regard to the reply to a question doesn't amount to offer. Can anybody frame any other example? Suppose if I ask you what is the price of the book which you are holding, and you have told me 100 rupees, and I said that okay, give me the 10 book of that. So do you think it is an offer when you have mentioned me that 100 rupees is the price of the book?
Ma'am, it's an invitation to offer.
Okay, what do you mean by invitation to offer?
An invitation to offer, when accepted, it becomes an offer.
When?
It is accepted by the offeree, then it is become an offer.
Yeah, I mean, yes, invitation to offer is the first step, and the second is your offer only. That is correct. But when just by giving the price, I mean giving the amount, no, just by giving the answer with regard to one question, that doesn't mean that you are also intending to invite an offer. You just simply said that the price amount, that doesn't mean that you are inviting an offer. Okay.
Okay, ma'am.
So, in what exactly the purpose of no, when we give the invitation to offer, what is the purpose behind it? It is the underlying purpose is negotiation. So, but when you are giving an offer, there is not any kind of negotiation. In case of offer, all the terms and conditions are definite. Because see, if you have mentioned that it should be certain, definite, and not vague, right? So all the terms and condition is already stated in the offer. It might be conditional, it might not be, or anything you want to put in a term and condition. But in case of invitation to offer, there is nothing like that. It is not certain. You're inviting, you are just saying that ki, I want to sell this book, right? If you may have mentioned that you are inviting an offer, I want to sell this book at 100 rupees, but you have not no you just saying that ki you are no intended to sell this book. But if you say that do you buy this book at 100 rupees, that means you're giving an offer. So like a shopkeeper is keeping any cloth and wherein he is giving a tag of certain rupees, which is not that shopkeeper is not selling having a fixed price shop. ठीक है? इस उस केस में क्या होता है कि आप जाते हो, आप प्राइस देखते हो और फिर आप क्या करते हो, आप नेगोशिएट करते हो कि अरे भैया आपने इसमें लिखा है 100 रुपीज, क्या आप इसको 60 रुपीज में दे सकते हो या नहीं? करते हो ना आप ऐसा?
Yes, ma'am.
सो वहां पे जब उसने वो जो उसने मतलब आपका जो भी मटेरियल उसने रखा है अपने शॉप में, तो एंड कीपिंग विद द प्राइस, दैट मींस ही इज इनवाइटिंग एन ऑफर. बट you simply reading a book and somebody asked you that what is the price, you are not intending it to sell it, right? You simply answered it.
Yes, ma'am.
Yeah. So in case of certain example for the no invitation to offer is your catalog of goods, tender, prospectus, menu card, newspaper advertisement. Now in case of tender, if you see that if tender notice you would have seen in the newspaper, wherein the person is inviting the person is inviting to the others to buy that or to offer a price for that. He's mentioning all the details of the property, immovable property, and I'm giving the example of tender. Suppose in case of tender notice for the your uh, any of the contract also, like whoever want to, everybody will is going to know, give their offer that they will do that work at certain price, and whoever has given the best quotation, that person will be selected by the government department, right? This usually happen. So
Yes, ma'am.
what is exactly happening here? It is a negotiation. But in case of offer, there is nothing like that. The moment you negotiate, it is not an offer. What it becomes?
Ma'am, it's
Invitation to offer.
invitation.
No, 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 no. You're getting confused. See, um, I have mentioned, we have just discussed about, wait. Yes, we have just discussed about acceptance. It's not. Okay, fine, leave it. So we have discussed about acceptance, that it should not be it should not be no having any condition, correct? So you have to accept it as such, as it is, what the offer is. You cannot put yourself any condition to it. Okay, you have asked me to come wearing a red dress, and if you will come wearing another dress, the offer laps there itself. You have to accept it as such. But in case of invitation to offer, what is happening? We are negotiating. There is no offer happened. The moment both of you agreed upon certain thing, then it is an offer. So suppose Ananya, you have no somebody has opened a shop wherein certain material is there, and the price tag is 100, and the moment you have said, okay, I want to buy it, will you will you sell it at 60, and the other person has handed it over to you, that means you have given an offer and the other person has accepted it. But suppose it's a
Yes,
fixed
ma'am.
price, suppose it's a fixed price showroom, and if the price, if the tag is 100 rupees, you have to either buy it at 100 rupees or you have to leave it. But
Yes, ma'am.
but the moment you give a offer that 60 rupees, then it is a counter offer. The first offer is your 100 rupees. The second, if you're saying the 60 rupees, the first offer left and a new offer came.
Yes,
So,
ma'am.
so it is different. So in case so it is completely altogether different. Okay, so in case of catalog of good also the same thing is there, that in case of tender also we have explained, the prospectus is like uh, for subscribing shares, you are no offering the price, like at this price you want to buy the shares, and whoever first whatever the lot they have agreed, and whoever given a higher price offer, those person will get that share. Okay, and who has given a less offer might not get it, correct? In case of menu card also the same thing happening, newspaper advertisement. I hope any of these pointers, if you have any kind of no query, then we can discuss it further. Okay, this is again, your father said, I wish to give you BMW. Is this a offer?
No, madam.
Okay, correct, very much, because it is not definite, right? He just wishing it. Kinds of offer. So we have already understood how the offer is given. It might be an expressed one, it might be an implied one. To whom it will be given? To the entire general public or to a specific person. Now the classification offer, general offer we have discussed, and this second is your special offer or specific offer. For this you can no, go through this case law which I have specified, Bolton versus Jones. Okay, the example which I have given you, the specific group, it is similar to that. And the third is counter offer, wherein if you're not no accepting the entire terms and condition, or whatever the condition attached to the offer as it is, and you are just giving another no another proposal, then it become a counter offer. So suppose if you are saying, if I just no give you one example. Suppose if you're saying suppose Soumya, you give an offer to Ananya that this task should be complete. Suppose you have asked for certain you have offered him her to give to perform certain service. Okay, and she agreed, and you have also given a timeline that by 23rd of April it has to be completed. Okay, Ananya mentioned it that it will be completed by 26th. Do you think the contract made?
Ma'am, if the person
Madam,
accepts the counter offer, then it is made.
Mm-hmm. Yes, Soumya, you are saying something.
Ma'am, when counter offer is accepted by me, then only it is binding.
Yeah, but the first offer is lapsed.
Yes, madam.
Yes, ma'am.
Okay, this you have to keep it in notice. Counter offer is a completely altogether a new offer. And the fourth is your cross offer. Suppose Ananya want to perform the work, and Ananya by herself given that proposal to you, irrespective of awareness, that irrespective because she is not aware that you have already told, you have already no, communicated the same, that you want that kind of service from her. Like suppose if you have given an email stating all the terms and condition and the task which you want to be done it through Ananya, and Ananya also emailed you the similar thing, that she want to perform this task at in your company and wanted this revenue. Everything is same, all the terms and conditions are same, all the no the exact service is same, the consideration amount is same. So what do you think, is this a valid contract?
Ma'am, both sides have offered at the same time without knowing about the other's offer.
Correct.
So, ma'am, they cannot be made as valid contracts.
Correct. Because it is a cross offer. Okay, so it is only an offer, both is giving only offer to each other and having the same thing. Still it is it is not considered as a valid contract because the acceptance is not possible. Both has given only offer to each other. The Somya what has provided to Ananya will amount as offer, and Ananya has provided whatever the emails to Somya, that will also consider as an offer, not an acceptance. That is the key. Okay. And last is your standing offer. Standing offer is like when you have given an offer and it has not lapsed, it is like for certain duration and it is there. So during that period of time it will be called as a standing offer until it is accepted. Okay. So lapse of offer. So we have already discussed about counter offer. The moment we give a counter offer, the first offer lapse by passage of time. So there should be a reasonable of time duration, or you have already mentioned certain timeline that you have to perform it by 23rd. If you don't perform it by lapse of time, that offer is also lapsed. Later on 24th you don't come and no, you are saying that okay, I am willing to perform that. That will not be considered as an acceptance. Okay, because that offer end there itself by rejection. If Ananya reject it, then itself then again that offer will lapse by notice of revocation. So what do you mean by notice of revocation?
To revoke the offer.
Okay, and when I have discussed in the class about revocation, and tell me if anybody has attended that class, what exactly the terminology?
Ma'am, revocation and rescind.
Correct, correct. So when revocation is possible, when you can rescind the contract.
Ma'am, revocation is like withdrawing the consent before the contract is formed, and rescind means to withdraw after the contract is formed.
Correct. So in case of so revocation is possible both for the offer and for the acceptance.
Ma'am, revocation of offer.
Okay. Okay. So by notice of revocation, so if the offer is not reached to the person, right? So before that itself you can revoke it. Or if it is reached to the person but the acceptance is not given, before that you can revoke it.
Ma'am, before the acceptance is not given.
Correct. I hope it is clear.
Yes, ma'am.
Yes, by failure to fulfill condition precedent to acceptance. Yes, this is one we have already discussed, that in case of offer, the condition might be there is the conditions, but if you are not no accept, if you're not fulfilling all the condition which is precedent to acceptance, then it is again lapse of offer. But death or insanity of offerer. So suppose the offerer has given already an offer to you and he died, but you are not aware about the death, then in that case that offer is valid offer. Okay, it will not lapse, and you have accepted that offer, then in that case the person who has offered, his legal hires or her legal hire has to perform it, and unless it is not dependent upon his personal qualification, like any artwork or something. Okay, but in case of artwork also, suppose a legal hire has done it and you have accepted that, then again it is a valid offer, a valid contract. I hope you understand that, or it is
Yes, ma'am.
huh. So but if it is in the knowledge of the offeree that the person has died, then in that case it is not a valid contract, it will lapse, the offer lapse. Okay, by subsequent illegality, sorry, just a minute. So if any change of law, like in case of a cryptocurrency transaction, suppose the party has into a transaction of cryptocurrency, but in the because of the change of law it become illegal, then again the offer will lapse.
Yes, ma'am.
So we have just discussed that the moment the acceptance is happened, then it is a valid contract. You cannot revoke that contract. You can rescind it. So acceptance is to offer with a lighted match to a train of gunpowder. You cannot change anything with that. It's done. Okay. So the legal relationship is created when the moment acceptance happen. When you give an offer but the person has not accepted it, then obviously there is no legal relationship happened between you and the other person. The other person has given the acceptance over this, then now you are into a contract and you have certain legal relationship between each other. Okay, so acceptance must be absolute and unqualified. This case law you can refer. Second is given by a person to whom offer is made. So suppose uh, offer is made to a flat number 1. Okay, but the flat number 2 has accepted has given the acceptance. Is it possible? No, right?
No, ma'am.
Okay, so similarly, suppose you are suppose one offer to find out nephew, and rupees 500 has been given as a prize money, and this is only communicated to flat number 1, but not to the flat number 2, and the flat number 2 is get to know from flat number 1 and found nephew of xyz, then in that case will the flat number 2 will get that prize money?
No, ma'am.
Ma'am, it's said to be made to specifically flat number 1.
Correct.
So flat number 1 is supposed to get the prize money.
uh, it is searched by flat number 2 only, so flat number 2 will not get, correct?
Yes, ma'am.
But suppose if it is given but this offer is given to entire public, but flat number 2 is not aware about that offer and found nephew. Now will that flat number 2 person will get the prize money?
Ma'am, it is essential to know about the offer, but as it is a general offer, might be eligible.
Hmm. Anybody else?
Ma'am, I think awareness of the offer is necessary.
Yes, because see, in the case law which no that woman is already aware about that there is an offer, and she has followed all the conditions attached with that offer, and that's why it was amounted as an acceptance and the contract is there. But in this case he's not aware about the offer. The offer must be communicated to the offeree, whether it is a specific person or to a general public. The knowledge of offer should be there. But if the person is not having the knowledge of offer and and has done something which is matching with that criteria, that doesn't mean that he is eligible to get the prize money.
Yes,
Clear?
ma'am.
Yes. And acceptance must be communicated. obviously this is again I have told that ki silence doesn't amount to acceptance. It should be through act or through a conduct or through an abstinence. Suppose if an offer is mentioned that you should not cut the trees and you have not cut the trees, and the rest of the particular tree you should not cut, and the rest of the tree you can cut, and you have only left that particular tree, and rest of the tree you have no done whatever the cutting is done, then in that case you have accepted it through your conduct or through your abstinence or through your act, right?
Yes, ma'am.
Given within fixed time before offer lapse. And suppose if there is no such fixed time is mentioned, then it should be within the reasonable time, given in some usual or reasonable manner. So if you will suppose the Soumya has given some task to Ananya, and Ananya has to communicate her acceptance, but she no communicated in she came physically at his house at midnight. Is that a reasonable manner?
No, ma'am.
It should be during the business hour. Then then only the acceptance will be valid. You will not later on say that okay, in midnight I came and I given the acceptance. That doesn't mean that that acceptance will be considered as an acceptance. Last is your mere silence is not acceptance unless previous conduct indicated. So suppose this is whatever we have discussed. The additional part is that suppose in earlier cases also, in earlier scenario also, the silence will be considered as a valid acceptance only. And many of time those things are like suppose your uncle has asked you to no come for a lunch, and you have not replied. He has also mentioned the time, the date, and everything, but you have not replied. But on the day, the specific date when you have supposed to come, you came. Okay. And this is always happening from last 5 years. Now on sixth year, when he has mentioned you, he considered even if you have not replied, that silence will amount as acceptance, because your previous conduct indicated that. Okay.
Yes, ma'am.
Last is your rejected offer can be accepted only when it is renewed. It is very simple. uh, with regard to this the last case law, it is basically about that the other person has kept the draft agreement in the drawer, and he has not responded. He's not but in that case it will not considered as an acceptance. But suppose on through a conduct, if you would have done it, whatever the criteria is required to be done, then it will amount to acceptance, right? So these are the few case laws you can go through. Yes. So communication of offer. So suppose the email communication which I have mentioned, that Somya has sent one email with regard to all the particulars of the task which Ananya has to perform. But Ananya has not email. So say suppose through a post. Okay, but Ananya has not read that letter, or through an email also, but Ananya has not read that email. So do you think the offer has been communicated to Ananya?
No, ma'am. Since it's not in my awareness, so the communication is not complete.
Yes, the communication will complete only when you read this email or the letter. Okay. And now the communication of acceptance. The communication of acceptance, the Ananya can either through an act, like you can either expressly say in words, or through an implied way you have communicated your acceptance. Then again the communication of acceptance is complete by an omission. So suppose that tree example which we have discussed, if you have left that one tree, then again that through omission also you have communicated your acceptance. But silence is not acceptance. However, we have no seen another case where when it is considered as acceptance. And your last is your communication by conduct, like in case of no when uh, you have seen in your no, station, some weighing machine is there wherein you have to pay certain amount and then you can measure your weight. So through conduct also you are accepting, because that keeping that weighing machine there, and there it is written that okay, if you drop if you no insert that particular amount of coin, you can have your weight. So that is an offer. Now by putting the same amount there, you are weighing yourself. Then through communication, through conduct, you are accepting the offer. Okay. Case law I'm not discussing. The underlying understanding is this. Okay. So communication is complete when it is in the knowledge of offeree, and acceptance is complete as against the offerer. So suppose the offerer has given certain in the case, same example, if Soumya has given an offer to Ananya to do certain tasks, and Ananya has given her acceptance through posting a letter. Okay, the moment you post a letter to Soumya, that moment itself the of acceptance is complete as against Soumya. So Soumya can revoke that. Soumya can revoke offer uh, only during the period of the time Ananya has not posted the letter, but not after that. But acceptance is complete when Soumya will receive that letter. Okay.
Yes, ma'am.
Just a minute. Someone want to join. So in this case, if Ananya want to revoke, is it possible to revoke?
No, ma'am. It is become out of power.
Okay. So, but in case of acceptance, when the acceptance is getting completed,
When it can
When it
comes
comes
into
to
the
his
knowledge.
knowledge.
to whom?
Ma'am, to Soumya.
Yes. Just here, this is wrong. Okay. Anyways, so when letter is to offerer, right? So to Soumya. So before the letter reached to Soumya, Ananya can withdraw her acceptance. But suppose if the letter of which Ananya has already posted, now that letter has been lost, and Ananya has satisfied all the criteria to post it perfectly, like no address, amount, stamp duty, whatever that has to be paid, it is done. The all the formalities has been done, but that letter has lost. Then in that case, whether it will result to a valid contract or not, because for the valid contract, there should be an offer plus acceptance.
Ma'am, only one party is aware of this acceptance, whereas other is not. So, how can a valid contract be there?
Ananya, you are aware that you have posted it,
Yes, ma'am.
and for Somya, when the acceptance is completed.
When he receives the letter.
No, 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 no. Here there is a confusion. See, as against the offerer, the moment you posted the letter, then acceptance is done as against Somya. So for offerer, the moment when letter is posted by Ananya, the acceptance is done. So the moment
Okay,
the
ma'am.
acceptance is done as against your Somya, that means Somya cannot revoke it. The offer can be revoked only when the only before the acceptance, not afterwards, and that should be as against Soumya, not as against Ananya,
Okay, ma'am.
right? So even if the letter has been lost, then also this will be considered as a valid contract. But what about
Okay, ma'am. Understood.
but what about if the acceptance is made over phone? Whether the revocation possible?
No, madam.
Okay, think about it. How it can be possible? Any scenario in your life wherein you communicating with some other person, and some other person would have not heard it what you are saying, and you have changed your instance, no, your
Ma'am, due to
stand.
network issue. Due to network issue.
Have you done it? What you are saying, you just changed your terms. Mm-hmm.
Yes, ma'am. Suppose there is a network issue, so
Mm-hmm.
acceptance not come with my knowledge, then only it's not valid.
Correct, correct. And most of you have done it. Like you might have said it, yes, I will come to a party, and then the other person has not heard. And meanwhile, you just thought, oh, I have to go to, no, my mother has given certain duty to me, and I have to perform that. I will not able to, or any other reason. You would have done it in your life. So even in case of no phone call also, if the other person has not heard it, or if the other person no you have not taken a confirmation from the other person the acceptance, meanwhile also you can change it. So you need to ensure that the acceptance and when you give an offer, the other person would have heard it clearly what exactly what exactly you have said, and the acceptance is also similarly you have to confirm it. So when the moment the both things is done, then only the contract happened. Now, in this case, where the contract happened, the place where, suppose, Somya, you are in Bhubaneswar and Ananya is in Delhi. I mean, you are in Odisha and Ananya is in Delhi. So, where the contract happened, in Odisha or in Delhi? Somya, you have
Ma'am,
given an
in Delhi.
offer
Ma'am, in Delhi, where the acceptance is, where is
made.
acceptance is made?
Correct, correct. Where the acceptance is made, that is the place of the contract. Okay. And
Yes, madam.
yes, one more important thing with regard to the revocation of offer, which we have discussed, it is same with in India as well as in common law. Okay, in England, but not with regard to acceptance. So when we are saying that acceptance, Ananya can withdraw the acceptance before the acceptance reach to the offerer. Okay, so but so here there is one more chance, like contract can be not possibly done if the Ananya withdraw it. But in common law, what happened? The moment Ananya has posted the letter, it is beyond Ananya control now. Ananya cannot have any option to withdraw that acceptance. This is the difference. I hope it is clear.
Yes,
Yes,
ma'am.
madam.
I think we have already reached to the time, and these things we have discussed about place of contract. Your UK case is there where the place of receipt of acceptance is there. Okay, and this is the case of UK, and Bhagwan Das Ji Kedia versus G Purushottam Das and Co, where acceptance is made, and Traders and Co versus Arnold Gin Co Company versus, this is USA case law where the acceptance spoken. So it is in similar line, right? And there is two things when we are discussing about the place of contract. Governing law is the law which your under which your right and liabilities are determined. But the jurisdiction of court is separate. You should not be confused with governing law and the jurisdiction of court. Okay, so jurisdiction of court, you have to read this thing, governing law and jurisdiction of court, uh, go through limitation act also. There is one section which talks about it, wherein the contract is made somewhere, jurisdiction is somewhere, and how the limitation act says about it. Okay, and the contract is made where the last person is signing. This is the task which I have given with regard to your limitation law. So when you are reading this, you can relate with that act also. Any question? If anybody is having question, that person can remain and the rest can leave the session.
Ma'am, the provision of gift is covered under the Indian Contract Act.
No, gift is not. Gift is a separate law.
Yes, ma'am. Thank you.
Anybody else? So we should end our class now. Good night. Bye bye all.
Thank you, ma'am. Thank you, ma'am. You have a wonderful day, ma'am.
Okay. Thank you. Bye
Thank
bye.
you, madam.